Hello CA Foundation students, this is our third revision video. I hope you liked the first two videos. It was on Indian Regulatory Framework and the second video was on LLP Act, and we have covered it in the minimum possible time, and it is a very exam oriented video. Similarly, this video is going to be about chapter number 6, the Companies Act 2013, and a very exam oriented video. If you watch it today and one day before the exam, you will definitely have confidence over the Companies Act. You will have to look this video into two parts because I am going to upload part A on one day and the second part will be uploaded again. So the first part, that is today's video, we are going to cover all the sequence is going to be from the module, and we are going to cover the basic things like applicability, what is the company, features of a company, corporate wheel theory, and then the types of companies. There it ends, and the remaining part we will do it in the next video. Coming straight to the topic, what is the basic thing that we should know? That the Companies Act has 29 chapters, which is having 470 sections, and it has 7 schedules. Very simple. The title is the Companies Act 2013. Extent, that is applicability, whole of India. Commencement, the first section came immediately, but others were notified on different dates. Applicability, it is applicable to all types of companies. It is even applicable to IBC, that is insurance companies, banking companies, companies engaged in generation of electricity. Also applicable to company which is governed by a special act and any other body notified by the central government. That is, you have to remember 6 points. But in case of insurance, banking and companies producing electricity, the respective acts will override. That means if the provisions are inconsistent in case of insurance company with the Insurance or IRD Act, in case of electricity company with the Electricity Act, or if the provisions of the Companies Act are inconsistent in case of banking companies with the Banking Regulation Act, then the respective act will be followed. That is about applicability. Now, what is the company? Section 2 clause 20 says company means a company incorporated under this act or under any previous company law. But this definition does not make us clear like what exactly a company means. So different professors and different people have given the definition, from which and from the different sections we come to conclusion that a company is an incorporated association which is an artificial person created by law having a separate legal entity and a perpetual succession. From this topic, we are going to move towards the topic of features of company. Now, the features of companies are not given in this Saransh, so we are doing it from the module. I have a memory trick for you. If there comes a theory question on the features of company, remember the mnemonic SAL PC: separate legal entity, artificial legal person, limited liability, perpetual succession, and common seal, right? For the feature of separate legal entity, what are the keywords that you should remember? Separate legal entity means when a company is registered, it is clothed with a legal personality. A person, it becomes a person which is different from the subscribers. Every member even can contract with the company. For the debts of the company alone will be liable. The creditors can sue the company for the debts of the company, but they cannot sue the members because now once incorporated, the company has become a separate legal person. Along with that, you should know that the shareholders are not the private or joint owners of the company's property. The shareholders are co-owners of the company, but they are not co-owners or joint owners of the company's assets or the company's property. From this point, separate legal entity, a case law, a question can be framed based on the case law of Macora versus Northern Assurance Company Limited. We are not going to discuss the facts in detail, but what you should know that a company is a separate legal person, and that is why a member does not have insurable interest in the property of the company. So if the insurance has to be taken on company's assets, the insurance should be in the name of the company. The insurance cannot be in the name of the member and the assets are in the name of the company. That cannot happen. So that is the case of Macora versus Northern Assurance Company Limited. Coming to next feature, perpetual succession. Members may die or change, but the company goes on till it's winding up. The company is a person created by law and it can be wound up only by law. The existence of members does not affect the company. The members may change, the members may die, or the members may become insolvent, but the perpetual succession feature ensures that the company goes on forever. Limited liability. The liability of member is limited, but it depends on the type of company. It can be limited liability company, it can be a limited company limited by guarantee, or it can be an unlimited company, which we will discuss in detail under types of companies. And that same point you can write here. Another feature, SAL PC, separate legal entity, artificial legal person. So artificial legal person means artificial Q because it is created by law, it is not created by natural birth. Person because it is since it can enter into contracts, it can own property, have banking account, raise loans, and it can enter into contracts on its own. So that is why it is having all the rights of a individual, and it is legal person because it is created by law. That is about artificial legal person. Coming to the feature, last feature, common seal. Is it compulsory to have a common seal? No. What is a common seal? Because a company is an artificial legal person, it has to act through the agency of human beings, and that is why common seal acts as an official signature of the company, which the employees and officers of the company will use as a symbol of incorporation of the company on every document. Companies Amendment Act 2015 has made the common seal optional, and that is why if a company on today's date does not have a common seal, the authentication will be done, authorization will be made by 2 directors. If the company secretary is not there, 2 directors. If the company has appointed a company secretary, the authorization will be done by a director and a company secretary. Now coming to the theory of corporate will. Whenever there is a question on separate legal entity or artificial legal person, separate legal entity, that is the separate legal entity and corporate will theory, there can be a combined question based on different case laws. Firstly, need to understand what is corporate will. Remember the keywords. It is a legal concept whereby the company is identified separately from the members of the company. In other words, members are shielded from the liability connected to company's actions. So if any of the violation, any of the liability is incurred by the company, then the actions are of the company and not of the members, and so members are protected, they are shielded from any of such liability of the company. In short, they enjoy corporate insulation. The case law Salomon versus Salomon and Company Limited has to be quoted, which laid down the judgment of corporate will, that is the company is to be considered a separate legal person and the members are considered as separate person. They are not acting as agent of the company. But can this corporate will be lifted? What is the meaning of corporate will? It means looking behind the company as a legal person, that is disregarding the corporate status of the company and looking behind who is actually controlling the company. So in some cases, specific cases, the court can decide to lift the corporate will or pierce the corporate will and look behind the company who is actually controlling the company. And at such times, the court disregards the corporate status of the company and they will punish the people who are actually controlling the company. Now you will realize that they have disregarded the corporate status and they are punishing members or the person who are controlling the company. They can be directors also. Whoever is controlling the company, those people will be punished, and the action is of whom? The actions are going to be of the company. They are done in the name of the company, but we will punish the people who are controlling the company. So the cases where corporate will can be lifted. I have a mnemonic for you. If there comes a theory question on cases where corporate will can be lifted, remember the mnemonic ETAAF, ETAF. ETAAF, ETAF. E is trading with enemy. So to determine whether a company with whom the trade is done, whether it is an enemy company or a friend company, the corporate will be lifted. We will look into whatever specific points are there under each of the cases, but remember the mnemonic first so that the theory question is easy for you. ETAF, T, if a company form of organization is incorporated to evade tax. A, where the company form of organization is incorporated to act as an agent, where the subsidiary is used to act as an agent to avoid legal obligation, where the company form of organization is made just to avoid some legal obligation. And F, if the company is formed for fraud or illegal or improper purposes. ETAF, right? And they have a specific case law for each of the point. To remember the case law, remember the mnemonic DDWMG. ETAF DDWMG. So enemy वाला जो point है उसके लिए कौन सा case law है? Daimler Company Limited versus Continental Tire and Rubber Co. D. Dinshaw and exhibited the case of evasion of tax. W, workmen of Associated Rubber Industries Limited versus Associated Rubber Industries Limited and others. This is the case law for lifting of corporate wheel where the company is formed to avoid legal obligation. DDWM, M means Merchandise Transport Limited versus British Transport Commission, where the company was incorporated, the subsidiary was incorporated to act as an agent of the parent company. Then G, DDWMG, Guilford Motor Co. versus Horney, the case where company was incorporated for fraud or for defeating law, right? So these are the cases of lifting of corporate wheel. You should remember. Now you know what you can do. You can directly, if you're not still having confidence over what you have highlighted, check that on the last day you just have to underline these words and you have to look into these words. You will be able to explain. Otherwise, what happens when the question comes on lifting of corporate wheel, I have seen the students doing this. They write in the paper just the heading and the case law, or just the headings, and they don't know what to write in the explanation, and they don't even remember the case law. So I have done it easy for you, right? We have discussed this. Determine the character of the company. Now the company cannot be directly termed as a friend or an enemy, right? So unlike a natural person, a company does not have any mind, but it cannot be like directly termed as a friend or an enemy, but we can look into who is actually controlling the affairs of the company. And if the people who are controlling the affairs of the company, they belong to an enemy country, then we will term that this company is incorporated, which is incorporated in even in our country, but it is controlled by people outside who are enemy country, belonging to enemy country. Then we will decide the character of the company as an enemy country. Then case where the company was incorporated to evade tax. They will give all the facts which are similar to Dinshaw Manekji patent case law, and they will ask whether the court will disregard the corporate status, right? So what was the case law of Dinshaw Manekji patent? A company was formed and he transferred all his dividend income. We are going to discuss it in very short manner. So this Dinshaw Manekji patent, what did he do? He incorporated a company just for evasion of tax. How? He incorporated the company and all his dividend and interest income on the shares and the debentures was transferred to this new company, and all the income was given to this Dinshaw, the SEC, by way of loan. Now in this case you will realize that the loan was never repaid. So that is why the court disregarded the corporate status and considered these companies as sham and considered Dinshaw and these companies as single person. Case where the company did another case where the company was formed to avoid legal obligation, that is to reduce the payment of bonus to the workmen. Now what did these people do? They created a company, subsidiary company, and transferred to it all the investment holdings in a bid to reduce liability to pay bonus to the workers. Now Supreme Court brushed aside the separate existence of the subsidiary company because they realized that the new company which was formed had no assets of its own except those transferred to it by the principal company. The new company did not have any business or income of its own except receiving dividend from shares transferred to it by the principal company. So the dividend income was transferred, in short, to the new company. Only that much was done, and only for this purpose the new company was incorporated. And that is the reason the bonus got reduced, because the parent company's profit got reduced, right? So in this case where the company is formed to avoid legal obligation, the corporate status will be brushed aside. Another case where the Merchandise Transport Limited, this company formed, it was a transport company, wanted to obtain license for its vehicles, but there were some defaults because of which the company could not apply in its own name. So it formed a subsidiary company and the application of license was made in the name of subsidiary company. Now in this case the vehicles were also transferred to the subsidiary company, but it was held that both the companies should be considered as one commercial unit because the subsidiary company was incorporated just to act like an agent of the parent company, right? Another last case where the corporate wheel will be lifted is where the company is incorporated to do some improper conduct, business or fraud. This was the case of Guilford Motor Co versus Horney. If you remember the case law, in short, I would like to brief you that this person Horney, he wanted to avoid the contract which he had made to his previous employer, and that is why he did not avoid the contract directly by doing any activity himself, but he incorporated a company form of organization. So that was a clear case of fraud. Now coming to classes of companies, the types of companies on different basis. So it is on the basis of liability, on the basis of number of members, on the basis of control, on the basis of access to capital, and other types of companies. Coming to types of company on the basis of liability. In case of company limited by shares, आपको याद होगा, the liability of member is going to be limited up to the amount which he has not paid on the shares which are held by him, and this amount, the liability of the members being limited, it has to be stated in the memorandum. So the liability of members of a company is limited by what? Memorandum of association, and it is limited up to the amount, if any, which is unpaid on the shares held by the member. Company limited by guarantee के case में the liability of member is also limited, but it is limited up to the amounts which the member has undertaken to contribute to the assets of the company in the event of the company being wound up, and this liability is limited by memorandum. Members cannot be called upon to contribute beyond the stipulated sum, that is beyond the guaranteed amount which they have given in the memorandum. They can also ask the common features and the point of distinction between company limited by shares and company limited by guarantee. तो point of distinction क्या है कि यहाँ पे जो liability है ना, this will arise only at the time of guarantee amount. See 6.11 I have mentioned for you. This you can look into it. Here they have mentioned the point of distinction and they have also mentioned the common features. Okay, it is very easy. It was asked already, I guess, in the last attempt, so not sure, but once check it out. Then we have unlimited company. In case of unlimited company, there is no limit on the liability of the members, but very important that this limit, unlimited liability, this unlimited liability is arising only at the time of winding up. During the lifetime of the company, the liability of members is limited, and only at the time of winding up the liability becomes unlimited. So they can give you a question that there is no winding up case, but the creditor of the company files a case against the shareholder or the member to repay his loan taken by the company. Right, in that case the member of the unlimited company is not liable to repay the loan of the company, because the liability becomes unlimited only when the winding up starts, not any time before, and the liability ceases only when you cease to be a member. Coming to one person company. Now also one more point I remember for unlimited company. Say you left the company today, you cease to be a member today, but after 1 year, if within 1 year this winding up happens, then the person who was a member within last 1 year, he is also called to pay these liabilities, okay, if the assets fall short. Then on the basis of members, on the basis of liability हो गया, on the basis of members, first comes the one person company. So one person company के case में simple definition, which has only one person as its member, there is no minimum paid up share capital prescribed. The memorandum has to have a nominee clause. That means, what is nominee clause? The memorandum will indicate the name of the other person who shall, in the event of the subscriber's death, that is the member's death, be or his incapacity to contract. So if the member dies or he becomes incapacitated to contract, then in that case this new person will become, this nominee will become member of the company. But for becoming a nominee, when the registration of the company is done, consent of the nominee is required, written consent which has to be filed with the ROC, and this consent can be withdrawn by the nominee anytime. He will have to give a written notice, and the notice has to be given to the sole member and to the OPC, and then OPC will inform the ROC. That is the case. Now, who can the member of the OPC remove the nominee, change the name of the nominee? Yes, he has to give notice to the OPC, and the OPC will intimate the ROC. Now, if the nominee clause is changed, if the nominee changes, then it is deemed that this is not an alteration of the memorandum. Looking at the eligibility requirement, who can be a member or a nominee, दोनों का eligibility requirement same है. Firstly, natural person, company नहीं बन सकता है member या nominee, plus Indian citizen, foreign citizen नहीं चलेगा, plus he should be a major, that is minor cannot be a member or nominee of OPC. Natural person, Indian citizen and major person. Resident वाला clause अभी important नहीं है. Then at one time one person cannot be a member of two companies. Along with that, one person cannot be nominee in two companies. But can he be a member and nominee in, say, nominee in one company and member in another company? Yes. Now, if such happens that एक बंदा जो है, he is a nominee in one company and he is member in another company. If he becomes a member in this company, how he will become a member? Because say the member of this company dies. Now, automatically this person becomes the member of that company. Now, in that case, he becomes member at a time of two companies. So, that person has to decide in 180 days in which company he chooses to be a member. That is the extra thing which I have told you. It is not in the your syllabus module. Okay. Along with it, such company OPC cannot be incorporated to carry out the activities of Section 8 company. But can a OPC be converted into a private company or a public company? Yes, OPC is always going to be a private company. But कौन सा प्राइवेट कंपनी? मतलब मिनिमम 2 मेंबर्स वाला प्राइवेट कंपनी, या फिर पब्लिक कंपनी में भी आप कन्वर्ट कर सकते हो, बट यू कैनॉट कन्वर्ट इट डायरेक्टली इनटू सेक्शन 8 कंपनी. Such company cannot carry out NBFC activities. Such company even cannot do investment in any security of any body corporate. It cannot do investment in other body corporates. In this last line says that the member can be a sole member also and director also. So OPC can have the same person as member as well as director. And should it have compulsorily one director only? No, that is not the case. It can have more than one directors. Coming to the definition of private company. Private company means a company which has these three conditions. RLP, restricts the transferability of its shares, limits the number of its members to 200, and prohibits the invitation to subscribe to securities of the company. That means it has three conditions: RLP, restriction on transferability of shares, limits the number of its members to 200 except in case of OPC, and prohibition on invitation to public to subscribe any of its securities. That is a private company, right? Small company is always a private company. Small company का definition देखेंगे तब revise हो जाएगा. OPC is always a private company. When you count the number of members 200, the joint holders of the share are counted as single member, and in the counting of 200 you have to exclude the present members who are employees of the company, and you have to also exclude the ex-employees. That is, the person has left the employment but he became the member when he was employed with the company, and he continues to be member of the company even though he has left the company, right? That is private company. Coming to the definition of public company, it is not a private company. Articles do not have these restricting clauses. That is, RLP नहीं है उसके articles में. जो प्राइवेट कंपनी का कंडीशन है आरएलपी, ये कहाँ पे होते हैं कंडीशंस? दोज आर इन द आर्टिकल्स. सो पब्लिक कंपनी मीन्स अ कंपनी विच इज नॉट अ प्राइवेट कंपनी. Minimum number of members is 7. There is no limit on the maximum number of members. Another important clause in the public company definition is subsidiary of a public company is deemed to be a public company even though it is a private company in its articles. Right? इसका आप एक क्वेश्चन कर लेना. It will be clear for you, very easy yet important. It was asked in the previous paper. On the basis of control, there are holding, subsidiary and associate company. I already have a detailed video on this. You can check out the link which I will attach with this video. It will pop up and you can watch it out. We have discussed all the clauses in detail. Maybe you can do it, you can increase the speed of the video so that you watch it fast, because I have explained very slowly in detail. There you can control on the base, there you can cover up the types of companies on the basis of control. Holding company, associate company and subsidiary company. Quickly we will revise here, but we will not go into details and examples. There I have discussed the examples as well. Holding company, which I make the students learn definition, is holding company means a company which has one or more subsidiary companies. Holding company means a company which has one or more subsidiary companies. Subsidiary company means a company in which the holding company controls the composition of board of directors or exercises or controls more than 1/2 of the total voting power, either on its own or together with one or more of its subsidiary companies. Along with that, you have to mention control of composition of board of director means this holding company can appoint or remove majority or all of the directors. Also, you have to mention that about two controls, that is control of composition of board or control of more than 1/2 of the voting power, these control can even be by any of the subsidiary company of the holding company. That means it is chain subsidiary wala clause, right? For detailed explanation, watch that video. Also, you can mention that for these purposes, for these clauses, The company means and includes, company includes a body corporate as well. वो वाला पॉइंट भी हमने वहां पे डिस्कस किया है. देन कमिंग टू एसोसिएट कंपनी मीन्स अ कंपनी इन विच अनदर कंपनी हैज सिग्निफिकेंट इन्फ्लुएंस एंड बट such company which has significant influence does not is not a subsidiary. Such company which has a significant influence but this company does not become a subsidiary of that company and it includes a joint venture. Associate company means a company in which another company has a significant influence but which is not a subsidiary of such company having significant influence and it includes the joint venture. What is significant influence? Control of at least 20% of voting power or control of business decisions or participation in business decisions under an agreement. Joint venture means a joint arrangement whereby the parties have joint control of the arrangement and they have rights to the net assets of the arrangement. On the basis of access to capital, listed company, unlisted company. Listed means which has any of the securities listed on any recognized stock exchange. Unlisted company means a company which is not a listed company. Coming to other types of companies. Government company, section 2 clause 45. Government company means at least 51%. So in case of holding company, subsidiary company, वहां पे क्या होता है, subsidiary company में it is more than one half, that is more than 50%. यहाँ पे it is at least 51%. So 51% and above, वहां पे more than 50%. ठीक है. गवर्नमेंट कंपनी और 20% जो एसोसिएट कंपनी वाला है वहां पे क्या है, कंट्रोल ऑफ एटलीस्ट 20%. कहा गया, हाँ, एटलीस्ट 20%, राइट, 20% एंड अबव. गवर्नमेंट कंपनी मीन्स अ कंपनी इन विच एटलीस्ट 51% ऑफ द पेड अप शेयर कैपिटल इज हेल्ड बाय सेंट्रल गवर्नमेंट और स्टेट गवर्नमेंट और पार्टली बाय सेंट्रल गवर्नमेंट एंड स्टेट गवर्नमेंट, दैट इज दोनों का कॉम्बिनेशन, राइट. सो व्हेन यू काउंट द 51%, you have to include only the government share. Don't include the share of a government company. If one government company has a share in this company, don't include that share while counting 51%. But government company definition also includes a company which is a subsidiary of a government company. So A Limited, B Limited. A Limited is a government company. B Limited is a subsidiary of this A Limited. Okay. And how it is a subsidiary? Because say it has 52% of the voting power. A Limited का B Limited में 51% का voting power का control है. So B Limited becomes subsidiary. B Limited will also be termed as government company. But A Limited का B Limited में holding है और ये क्योंकि government company है, ठीक है. अब A Limited का अगर कुछ share होता B Limited में और बाकी governments का भी होता, तो हम जब count करते थे तो इनका शेयर इंक्लूड नहीं होता था. ए लिमिटेड जो गवर्नमेंट कंपनी है उसका शेयर इंक्लूड नहीं होता था. आप कोई भी एक क्वेश्चन कर लोगे तो आपको रियलाइज हो जाएगा. One day before exam, I hope these concepts are clear. We are quickly just revising it. We cannot discuss it in detail with examples as well, right? But already I have covered it in different reels, so you can watch those. Different shorts, YouTube shorts videos. Coming to the definition of small company, it is always a private company. Do remember, it is always a private company. Read the name carefully, whether it is limited or private limited, and more conditions. At least 4 crore का paid up share capital. बिलो 4 करोड़ आपका पेड अप शेयर कैपिटल होना चाहिए. नॉट मोर देन 4 करोड़. अप टू 4 करोड़ चलेगा. टर्नओवर जो है अप टू 40 करोड़ चलेगा. फॉर May 2026 अटेम्प्ट, दीज आर द लिमिट्स विच आर एप्लीकेबल. डोंट लुक आफ्टर एनी अदर लिमिट्स. योर पेड अप शेयर कैपिटल शुड नॉट बी मोर देन 4 करोड़ एंड टर्नओवर शुड नॉट बी मोर देन 40 करोड़. अलॉन्ग विथ इट, इट शुड नॉट बी अ सेक्शन 8 कंपनी, इट शुड नॉट बी अ होल्डिंग कंपनी, इट शुड नॉट बी अ सब्सिडरी कंपनी, इट शुड नॉट बी अ कंपनी और अ बॉडी कॉर्पोरेट गवर्न्ड बाय एनी स्पेशल एक्ट. So कितने conditions है? Almost 6 to 7 conditions. Always a private company, paid up share capital not more than 4 crores, turnover as per preceding financial year का profit and loss account not more than 40 crores, not a holding company, not a subsidiary company, not a section 8 company, not a company governed by any special act. Coming to the definition of foreign company, section 2 clause 42, 3 conditions have to exist parallelly. It should always be incorporated outside India and it should have a place of business in India. Not only should it have a place of business in India, but it should also conduct any business activity in India. That can be through electronic mode or physically, anyhow. Always incorporated outside India, but having a place of business and conducts business activity in India. Formation of company for charitable purpose, section 8. 3 conditions. Formed for promotion of commerce, art, science, sports, etc. Uses its profit for the promotion of the object of the company and does not declare dividend to its members. It has to obtain a special license from the government And if you obtain such license, then you need not use the words limited, private, limited in your name, and you can adopt a more suitable name for your promotion of object. It enjoys same privileges as of a limited company. Your license can be revoked if the conditions are violated, such as if your activities are conducted fraudulently, or your object clause is violated, or your activities are not in public interest, then your license can be revoked. If the license is revoked, the central government may order to amalgamate this company with another Section 8 company having similar objectives, or the government can order to wind up the company. And if the license is revoked, you will have to use the words private or public, private limited or limited in front of your name. Some special points on which you can be tested. Section 8 company can call the general meeting by giving a clear notice of just 14 days instead of 21 days requirement. Along with it, I find this point important which can be tested, that a partnership firm, see, normally a partnership firm is not regarded as a person separately, so it cannot become a member in another company, but a partnership firm can become a member of Section 8 company. Also note that this Section 8 company does not require to follow the minimum number of directors or independent directors or any other committee clauses. So बहुत सारे clauses में उसको छूट दी गई है. Then what is Nidhi company? Quickly, Nidhi company means a company which is notified by the central government in the official gazette to be a Nidhi or a mutual benefit society. Okay. Dormant company, a complicated definition, but we are going to simplify it. What is a dormant company? Section 455 is given for dormant company. There is no Section 2 and clause. It is Section 455, where a company is formed and registered under this act for F or H plus no sat. Means what? It is formed for a future project or to hold an asset or intellectual property, and it has no significant accounting transaction. Okay. So where a company is formed and registered under this act, and this is for a future project or to hold an asset or intellectual property, and it has no significant accounting transaction, then such a company, okay, this type of company, or an inactive company मतलब क्या, वो आगे देखेंगे. This type of company which we discussed, or an inactive company, may make an application to the registrar, okay, by following the rules for obtaining the status of a dormant company. If this registrar considers the application, he will allow the status of a dormant company and issue the status or certificate of being a dormant company. Okay. In case, now what is an inactive company? ये वाला पॉइंट छोड़ सकते हो आप, इतना इंपॉर्टेंट नहीं है. इन केस ऑफ एन इनएक्टिव कंपनी, तो क्योंकि ये इनएक्टिव कंपनी में कवर ही हो जाता है मोर और लेस. व्हाट इज एन इनएक्टिव कंपनी? नो बी or no SAT for 2 financial years, or no FS and AR filed for 2 financial years. That is, it does not have any business or operation, or it has not filed annual statements, financial statements and annual returns for the consecutive 2 financial years, last 2 financial years, or it has no significant accounting transaction during the last 2 financial years. Such a company will be called as inactive company. ये तीनों में से कुछ भी एक हुआ, it will be called inactive company. So inactive company, or the company which is formed for F or H plus no SAT is there, then that is for a future project or to hold or an asset or intellectual property, and has no significant accounting transaction, it will be called as it can make an application for being a dormant company. Now significant accounting transaction यहाँ भी दिया है और inactive company के definition में भी दिया है. What is the meaning of significant accounting transaction? It means any transaction other than these 4 transactions. Any transaction other than these 4 transactions will be termed as significant accounting transaction. And if you are doing this significant accounting transaction, that is okay. But if you are not doing any significant accounting transaction, that means other than these 4 you are not doing any other transaction, then you can become a dormant company. So which 4 transactions are termed as significant accounting transaction? ROC को fees pay करना, any law के लिए, to follow any act or companies act or any other law, any prescribed fees if you have to pay. O&R, maintenance of office and record के लिए कोई भी पेमेंट करना, और shares allotment करना. 4 things. ROC को fees pay करना, any payment for fulfilling the requirements of Companies Act or any other law, any payment made for maintenance of office and records, and any allotment of shares to fulfill the requirement of Companies Act. These 4 transactions are termed as significant accounting transactions, and any transaction other than this, if you do, you cannot become a dormant company. Coming to the definition of public financial institution. See, I'm not going into definition actually, but I think what can come as a question is the conditions to be notified as a public financial institution. So actually public financial institutions are those institutions which are notified by the government to be a PFI. But the government can notify an institution to be a PFI only if it is established under a special act other than Companies Act, it is established under a special act other than Companies Act, or it has at least 51% of the paid up share capital held by government, central, state, or any combination. Okay, so these are the two conditions, any of which if fulfilled, the central government can notify the company, the organization as a public financial institution. So here we end the types of companies. I hope you found the video useful. The next remaining part of the Companies Act will be covered in the next video. Do check it out. All the best.